Good evening, everyone. Thank you again for joining us on trying to explore some of the legal issues that arise from what can only be described as an extremely difficult, complicated and nuanced subject of peer-on-peer sexual abuse or sexually harmful behaviour which takes place in a school setting or which is associated with a school. Now, this is a topic which has been the subject of statutory guidance since 2018, but really it was only in March this year, following the death of Sarah Everard, that there has been what can only be described as a tsunami of testimonies on the Everyone's Invited website, incorporating, I think, around 3,000 schools out of the 24,000 that we have in this country. So a significant minority of schools in the UK, with testimonies ranging from observations about what could be called, or what Laura Bates might call, everyday sexism, through to multiple allegations of serious sexual assault and rape taking place either in a school setting or more likely at parties or social spaces associated with schools. I'm Fiona Scolding, and I'm chairing the session today, and I'm joined by three of my colleagues. We all have experience in managing or dealing with situations in schools arising from sexually harmful behaviour between peers. I have done some work on it with the work I've been doing for the Independent Inquiry for Child Sexual Abuse, and I'm currently undertaking a review for a particular school. Joe is assisting me with that review, and Leon and Samantha have provided advice both to schools and to individuals as to the consequences which arise from Everyone's Invited. A few housekeeping matters. Firstly, all microphones are automatically muted, so you don't need to adjust your settings. Secondly, we very much welcome and would like questions and comments throughout the session. This is something which I think schools, local authorities, lawyers, the Department for Education, we are all currently working our way through how we manage and deal with the situation, because what's absolutely clear is nobody's done a terribly good job of managing it to date. Otherwise, there wouldn't be the number and scale of allegations and sexual harassment, which would seem to be rampant, uniform, and it's so common that it's in fact unremarked upon within our schools. And that's all schools, state, maintained academies, free schools, or at the independent setting. We're going to try and answer as many questions as possible at the end of the presentation. The webinar will be recorded and you'll receive a link to it shortly after the event concludes. If you lose the connection, please just click in on the Zoom link that was sent to us. So to begin, I pass first to Leon Glenister. He is a member of our education team. He has done work for the Department for Education, local authorities, various quangos and organisations and individuals on the topic of sexual harassment and sexual harm in schools. And he's going to talk to us about the legal duties that every school owes. Over to you, Leon. Thank you.
Thank you very much, Fiona. So this issue and safeguarding more generally, I find have always found quite difficult. And I know a lot of us are governors at schools, lawyers who work in the education sector, take on that role. And we always have safeguarding training, and we're given the situation, you're walking through the school and you see this, what would you do? And you get sort of the multiple choice questions. I almost always pick D, which is ask the designated safeguarding lead, because it is so difficult. And in terms of the legal issues, it's not much easier actually. And I'll try and take you through sort of the basic legal duties here. The theme that you'll see is that there are very few statutory obligations and duties. Those that are there are very general, and most of the specifics are set out in a host of government guidance, particularly from DFE, but others as well, both statutory and non-statutory. So you've got to look at the guidance, figure out its status, and then go from there. But I'll take you through some of the overarching points here. So what are the themes I'll be looking in my short talk? Well, one of the issues that comes up, and probably the biggest one in this area, is at what point do school duties stop? So do they stop at the school gate? I think we've quite clearly established that the answer is no, but schools are used to dealing with a fight on the playground, they're used to dealing with a fight at lunchtime outside of school, they're used to dealing with probably students fighting with school uniform after school. But at what point can schools intervene where there's a party on the weekend involving 2 students from their school, or even different students from different schools? And it's those kind of questions that arise a lot in this area. Secondly, what can a school do in terms of investigations? I'll cover this briefly. I think Fiona will pick up on this more, but particularly where the police are involved, can the school carry on its investigation in terms of discipline? Well, we'll look at that issue. And also, and lastly, what does the school do with historic abuse allegations? All schools, or many schools, were notified by various newspapers when the allegations were made because they were being reported on, but schools then had a decision of what to do and what they could do. So we'll be looking at that issue as well. So in terms of my talk, I will take it in 3 parts. One is safeguarding. I'll look at the statutory duty there. I'll then look at discipline. And then lastly, I'll look at historic allegations briefly. So let's take safeguarding first. Well, there is a statutory duty across all schools, essentially all schools, but it comes from different sources. But the duty is to make arrangements for ensuring that functions relating to the conduct of the school are exercised with a view to safeguarding and promoting the welfare of children who are pupils at the school. So that's for maintained schools, but the same duty arises for academies, independent schools, and that's set out in the regulations there. And there's also separate legislation for non-maintained schools, for example, but it's essentially the same contents. And that's the fundamental duty in relation to safeguarding. Just to clock a couple of things here. One is that it relates to the conduct of the school, and the other is that it relates to the welfare of children who are pupils, and those are the phrases which we may come back to shortly. In terms of guidance on the area, the key guidance is sexual violence harassment between children in schools and colleges, and then keeping children safe in education. The latter is statutory guidance, the former is non-statutory guidance. And it does contain a lot of helpful information. It's one of the areas where there is a lot of, as I say, guidance rather than legislative duties, and there's a lot of judgment in everything that's being done. Just to take you through some of the key principles of that guidance, particularly where legal issues will come up. So what does a school do when it's responding to a report? Well, sets out how the victim should be treated, but also what's the scope of the school's duty. Now, what the guidance says, this is what paragraph 45 of the non-statutory guidance for those of you who are looking at this, but it applies where the report is made away from the school premises. So the safeguarding duty is a general one, which the guidance says applies whether it's on school or outside of school. So the school gate analogy doesn't really apply in relation to safeguarding, at least, and that's a key principle. It also explains that it applies where both students are from the same school or both students are from different schools. So, for example, if school A finds out there are allegations which relate to, or there may be harm to a student B another student at school B, then school A probably has a duty to tell school B. I mean, that's a matter of common sense, but it's fairly clear from the guidance on offer. So it's safeguarding. The key takeaway point here is that it's a very general duty in relation to safeguarding. Then what happens after the report? Well, it sets out that there should be a risk assessment. It should take into account various things. There's a list. It's the wishes of the victim, the nature of the incident, the seriousness of the incident, the ages of the participants, various factors to take into account. That's all in a risk assessment. And then the designated safeguarding lead will consider how to deal with the incident. So the various steps, there's sort of 4 grades of seriousness, from managing internally on one end via early help, so sort of non-statutory processes, but dealing with it sort of more extensively than just as a one-off incident, referrals to social services, and alongside that, reporting it to the police rather than policy, reporting it to the police, and that's the most serious method of dealing with it in the guidance. And this is all in the guidance. This is will be obvious to you. Now, so that's safeguarding, all results from this one statutory duty. It's a bit different with discipline. So the statute, the statutory basis of behaviour policies generally is actually not, I found, not widely known, which is the Education Inspections Act 2006, and the head teacher is responsible for disciplinary penalties. That includes conduct which occurs at a time when pupils not on the premises and not under the lawful control of staff, but only to the extent that it's reasonable for the school imposing the penalty to regulate the student's conduct. So it is, there's a lot of discretion to the school, but it's not unlimited in the way that safeguarding is. So there's a tighter remit on discipline. It all will generally come down to behaviour policies. For example, I know a lot of behaviour policies that I've seen will include provision where students are wearing school uniform, and that's quite non-controversial. There'll be others in relation to weekend where students are the same school, for example, and those, but it'll all be down to the individual behaviour policy. And so the key documents here really are the policy, and also you've got behaviour and discipline in the schools, more guidance from DFE. If you're discussing exclusions, obviously there's the exclusions guidance from DFE as well. Where there are concurrent investigations, this is where the police are investigating as well as the school. The guidance doesn't stop the school investigating where the police are investigating, which is quite interesting actually, but it's specific about that. But the school has to consider on a case-by-case basis whether it's appropriate. And bear in mind, there may be different burdens of proof. So the police will be looking at beyond reasonable doubt. Schools will be looking at balanced probabilities. That's not necessarily unusual, because if any of you have done DBS work, disclosure barring service, often teachers will be acquitted in the Crown Court but still be barred because on a balanced probabilities, allegations were made out. And whether investigations would be prejudiced. So evidence that's being taken by the school may well be admissible in the criminal investigation. And this principle is actually slightly different to universities, because the universities UK guidance, those who work in the higher education sector, specifically states that internal processes should be stopped or paused while the police are investigating any incident, to stop this kind of cross-pollination and confusion. But I think the practical advice here is make sure, if you're a school, you're liaising with the police and others as to the appropriate way forward. Very briefly on historic allegations, what the school has to do in light of those statutory duties will depend on the allegations. So if the perpetrator and victim have both left the school, the safeguarding duty would unlikely apply, because it only applies to pupils at the school. But if a teacher, for example, an allegation made against a teacher who's still working, then it may well apply, because there may be a risk to current pupils. It's the same as discipline. If the student has left, obviously, then the behaviour policy will no longer apply, but it very much depends on the nature of the allegation in light of the duties I've set out. And on that note, that introduction, I will then pass back to Fiona, perhaps, who can move on to Samantha.
Yes, Sam needs no introduction. She's another silk. She and I are now, for our sins, the co-heads of the public law team. Sam has done a welter of education work over the years, particularly around safeguarding risk and the interrelationship between safeguarding duties and ensuring that young people's mental health and well-being is promoted within a school setting. So, Sam, over to you.
Thank you very much, and hello everybody. Right, so the context for all of this is, of course, the Ofsted report and the rapid review that they undertook following the Everyone's Invited website exploding with information and quite horrific tales. The report was commissioned by the government, I think, in April, and the rapid review came out on the 10th of June, and the link is there in case anybody wants to find it later on. To give you some of the context, of course, as everybody knows, the matter was all splattered all over the press, but some context is that the messages that came out was that the incidents are commonplace sexual harassment and online abuse, such as being sent unsolicited, explicit sexual material and being pressured to send nude pictures, are much more prevalent than everybody realised. For example, that nearly 90% of girls and nearly 50% of boys said they had been sent explicit pictures or videos that they didn't want to see. Most of the sexual conduct or violence occurs outside of school itself. That will be unsurprising, although there is quite a bit of sort of sexual groping or touching in corridors, for example, so that was something that was reported to Ofsted. And then the final point is the one that makes this so difficult for schools, which is that there is in general a real reluctance to report, even where schools take a proactive approach and encourage them to do so. I am the mother of 3 teenagers. I can say that just from my own experience, when one has conversations at home, there's a real level of sort of blasé-ness about, oh no, well, they won't do anything about it anyway, or what, we wouldn't want to get them expelled, or wouldn't want to get them into trouble, and all of those sorts of themes, are recurring themes reported to Ofsted. So certainly when I read the report, it was horrifying in its extent, but some of the attitudes that are reported were certainly not surprising and seemed to be entirely fit with experience of, being a mum. Now, the inadequacies identified, there are quite a lot, but in 3 I want to draw to your attention. The first is that the RSHE that children receive was widely felt by the kids to be too little too late, and simply did not equip them with the information and advice that they need to be able to navigate the reality of their lives. And this is absolutely a key issue. And part of what Ofsted identified was that people, is that the girls felt often that they were the ones that had to educate the boys in how they feel or how invasive certain, pressure felt. And, girls were resentful, understandably, about that. It's obviously not just limited to girls being pressured, but they are disproportionately affected. The second point is underestimating the scale of the problem. Many teachers and leaders underestimate the scale of the problem, especially the prevalence of online sexual abuse. And then the final point is that, again, not everywhere, not all schools, but there was a real, in general terms, lack of safeguarding training. And even where there was training, it was not always clear that this included specific training on sexually harmful behaviour. So they found that 25% of the cohort that they interviewed during the course of the rapid review had training, but it was unclear that even in that 25% how useful for this purpose it was. Again, there's a host of recommendations, and this summary probably doesn't do them all justice, but for these purposes there are 6 to better understand the definitions of sexual harassment and sexual violence, identify early signs of peer-on-peer sexual abuse, consistency in upholding standards in responses, understand the prevalence, obviously key, and what constitutes harmful sexual behaviour, know good practice, especially in relation to disclosures, and understand the prevalence of harmful sexual behaviour in all schools. So what are the responsibilities of the schools? Well, Leon has helpfully set out, the statutory responsibilities and, where they are to be found, and is absolutely right to say that they're expressed in general terms. And I've repeated to some degree that here. But I'm interested particularly in what follows, because the guidance that has emerged recently and the combination of it with the review, Ofsted review, means that I think that it changes the standards of what a school is expected to do and the content of their duty of care. So there's new guidance that came out in June, I think June the 2nd, in fact it was updated on June the 15th, from the DFE on guidance on promoting and supporting mental health and wellbeing in schools and colleges. And there's a particular focus on the type of wellbeing and mental health issues associated with the Ofsted rapid review. It draws on the 8 headings contained in Public Health England's guidance dated February, and again the links are there. So there are 8 principal areas which are set out. Now obviously they're all important, but in the 12 minutes or so that I have, we can't go through all of them, and I refer you to that guidance. But I'm going to focus on 2 of them for the purposes of this talk. So the first one is leadership and management, and the second is curriculum, teaching and learning, because these are the 2 that link most back to the recommendations and the failures identified by Ofsted in the rapid review. And at the end of a school's reappraisal of their own systems and policies, they need to be able to answer these 2 questions. And in fact, these 2 questions are probably a good starting point when one is reviewing, well, where has one got to, and what is it that the school actually does in relation to these 2 headings. So the first key question is, how is the school or college providing visible senior leadership for emotional health and wellbeing? And then the second one is, what focus is given within the curriculum to social and emotional learning and promoting personal resilience, and how is learning assessed? So under the first area of leadership and management, there's obviously the DFE guidance, the link, which is in an earlier slide. And the focus needs to be on developing or introducing a whole school or college approach to mental health, and that often involves strategic change, ideally overseen by a setting's senior mental health lead. But, and this is an important point, school staff are not expected to and should not diagnose mental health conditions or perform mental health interventions. So how does a school do that? Well, the novel or the new point that has emerged in this guidance is that the Department for Education is offering grants for training to develop a senior mental health lead in every state school or college from this autumn. And where established, mental health support teams should also support senior leads to develop their approach. And we're going to look at both of those in a moment. Who is eligible? All state schools and colleges in England will be eligible for a training grant. And this senior lead training gives senior leaders the knowledge and skills they'll need to develop in order to develop an effective whole school or college approach to mental health. And it introduces new approaches to promote and support mental health. And the benefits are set out in the guidance, but it includes learning to use your existing resources more effectively, how to identify individuals who might need support with their mental health, and to promote good mental health in your setting. Now, the availability of the grant, it's available for a third of all state schools and colleges in the 2021 to 2022 financial year, and there's a wait list which will be created for grants beyond this period. and settings that are ready to develop or introduce their whole school or college approach with capacity to undertake training before March 2022 will be encouraged to apply. And the aim is that all state schools and colleges will be giving access to this training by 2025. The other aspects to this guidance provide for 5 additional resources to support schools in this task of improving their procedures and their policies within schools. The first one is Wellbeing for Education Recovery. This was launched in August last year and has, I think the department has invested a further £7 million in developing the programme. It's being targeted at the areas with most need, so it depends where the school is that might, as to whether or not they'll benefit from it, and schools should contact their local authority to find out whether their local authority is participating. The next area is the LINK programme, and again this is only certain local areas will be participating in the LINK programme, and again it's has to be contacted via the local authority, and I think that it's up to 50 upper tier local authorities can take part in the 2021 to 2022 academic year. Then there's mental health support teams. This is for schools and colleges in participating mental health support team areas who want to work more closely with mental health professionals in their local area, and they receive additional mental health and wellbeing support and extra capacity for early intervention. Again, it's targeted in the areas where there's the greatest need, but you can find out if your area is on it by using the NHS website. There's also psychological first aid training, and again there's more detail available on the website about that. And then finally there's an extremely long list of mental health and well-being resources. Why do lawyers need to know about this? Well, they need to know because if there is a complaint either from parents or from parents to school or from pupils, or something goes horribly wrong, people will be looking at, well, what did you do about it? Where are your policies? Did you review them all? Did you make an application to have access to the grant? Did you take advantage of these other resources that may or may not be available? And so it's important for us as lawyers to know what additional material and support and training is available. The second aspect then was the curriculum, teaching and learning, and the RHSE modules. Obviously they have to be taught in school. There's a lot of information available on the website about what needs to be taught and how to deal with tricky questions, etc. The other 2 bullet points are self-explanatory about encouraging physical activity and using the character and education framework. But dealing with the teaching, the RHSE training modules, I've put the links in as to where those can be found. Now, obviously, again, as lawyers, you don't need to know specifically about planning your RHSE curriculum. But again, it's relevant if you have a situation where procedures haven't or policies haven't been developed in the way that they should, and there's been problems, and all of this is likely to be raked over. There's a section on handling difficult questions and a link to the section in the statutory guidance, etc. There is, of course, also a safeguarding reports of abuse and confidentiality section in the statutory guidance that is essential reading. and staff should know how to manage the requirement to maintain appropriate levels of confidentiality. There are additional resources, some of which in fact have been updated. It is some of it is already updated. And then finally, although this doesn't specifically fall under the curriculum, teaching and learning resources heading, it's worth putting in here, which is there is specific advice available regarding the very difficult issue when a disclosure is made about the sharing of nudes or semi-nudes, which tries very hard to tread the difficult tightrope of how you deal with that in circumstances where the adult or the teacher's obviously not allowed, shouldn't look at it, shouldn't have it, but it is a very useful guidance. So that's my talk in a nutshell, and I look forward to hearing questions later.
Thank you very much, Sam. Now pass over to Joe. Joe does the thing that everybody hates, but is absolutely necessary, particularly in this area, which is information sharing and the GDPR. We get asked lots of questions about what can be shared, what can't be shared. I'm not sure any of us have all the answers, but Joe, I think, is going to try and help us through that maze.
Thank you very much, Fiona. So I know that this is obviously a subject that everyone feels is very complex, just building on Leon's point, and it is complex. So I'm only going to be dealing with the legal framework in outline, but what I'm hoping to give you today is reassurance that you can share information without consent in certain circumstances. So very briefly, I'm sure you're all familiar that a couple of years ago we got thousands of emails saying we need to update our data policy because of the general data protection regulation. Now, the way that the law works here is there is the general data protection regulation at a European level, and it still applies post-Brexit, and then that's complemented and enhanced and clarified by the domestic legislation, the Data Protection Act 2018. So I'm going to be referring to both. So how the GDPR works is it sets out some broad principles, and then it has some more detailed rules, and then those rules are then clarified at a domestic level. So starting with those principles, so when you're processing data, which in processing is exceptionally broadly defined, so it includes disclosure or sharing, and it follows the principles under Article 5. So it must be lawful, fair and transparent, it must be collected for specific purposes, adequate, relevant and limited, accurate, kept for no longer than necessary, and it's got to be secure. So that's the principles that underpin the GDPR. So your first question as lawyers is probably, well, what makes it lawful? So we turn towards Article 6 for that. Now, the starting point is actually that processing of data, including disclosure or sharing, is prohibited unless there is a lawful basis. Then Article 6 goes through what constitutes as a lawful basis. So you've got consent, it's necessary for the performance of a contract, performance of a legal obligation, such as your safeguarding duty. Processing is necessary in order to protect the vital interests of the data subject or another natural person. And I'll come back to the language there in a second. And then there's public interest. And then Article 6 says that C and E can be clarified and expanded under national law. So that's how it works. But then we've got this special category of data, Article 9. And special categories of data includes data concerning an individual's health, their sex life, or their sexual orientation. And when you're dealing with safeguarding matters regarding harmful sexual behaviours, you will be dealing with Article 9 data. And there, the permission for processing that data is more limited, and it's spelled out in much more detail. I think there is up to 8. It goes up to subparagraph H here, but I've only identified a few of those that are most relevant. So as I can say, I can only operate at sort of a broad high level here, and if you need specific advice on a specific case, that would be something you would have to go through on an individual basis. But Article 9 says that you can process special categories of data with consent, and then you get subparagraph C, and subparagraph G. And subparagraph C is it's necessary to protect the vital interests of the data subject or of another natural person, where the data subject is physically or legally incapable of giving consent. So subparagraph C only applies in those circumstances when the data subject can't give consent. So then you turn to subparagraph G, which is processing is necessary for reasons of substantial public interest on the basis of the law, and then goes on to say that it's proportionate. Now, coming back to what I said earlier about how the Data Protection Act 2018 works, is it assumes that the GDPR applies, and then it complements it and expands on some of those details. And for our purposes, the relevant parts are Section 8 of the Data Protection Act that clarifies the public interest under Article 6, going back here. E includes the administration of justice. So therefore, if you need to disclose data or information as part of a criminal inquiry, then you have permission, you have a legal basis there. Section 10(3) of the Data Protection Act says that the processing meets the requirements of point G, if I go back to the slide, substantial public interest, is only allowed if it meets the conditions under Part 2 of Schedule 1. So then we have to go to Part 2 of Schedule 1. Now that's actually got quite a lot of paragraphs to it. But the most important for our purposes is paragraph 18. So, processing which is necessary, protecting an individual from neglect, physical, mental or emotional harm, or protecting the physical, mental, emotional well-being of an individual, and the individual is aged under 18, so that would be the vast majority of school pupils, or is aged 18 or over and at risk. And then it goes on and then says you can't get the consent, or it wouldn't be reasonable to get the consent, or it would prejudice the provision of protection, etc. So in those circumstances where you cannot get consent and it's and an individual is at risk. But you can only process data under the powers of Part 2, paragraph 18, or any of the paragraphs under Part 2, if you have a policy. So you do need to develop your own policy, and the institution will have to have its own policy. But thankfully, to aid you in developing that policy, we do have the July 2018 guidance, which is quite practical and understands the challenges that you or your institution will be facing. And it does, but it starts off by stating in very clear categorical terms, the GDPR and the Data Protection Act are not barriers to data sharing without consent where it is appropriate to do so. However, you must meet those underlying principles of GDPR. You've got to be open and honest about when information will be shared. So when you're developing that policy, you need to state, we will be sharing information when we believe an individual is at risk. It is obviously very sensible to seek advice, e.g. the LADO. Wherever possible, you want to be seeking consent, but bear in mind, there will be occasions when consent is not appropriate or will be, or it would prejudice an investigation, so you shouldn't be even asking the question of consent. The question of whether or not you share data has to be based on the safety and well-being of others, and you have to take into the interest of the data subject. So you've got to be very careful about what your relevant considerations are there. You need to only share what is relevant. So for example, if you know that a young person is at risk because of who her or his partner is, then it'll be relevant who the partner is. The fact that she might take illegal substances isn't necessarily relevant to that question. So you wouldn't be passing that second part of the information in, only if it was relevant to these harmful sexual behaviours. And then obviously the data has to be relevant, proportionate and adequate. And the final point is when you make these decisions, and these are difficult decisions, you have to keep a log of your decision, the decision you've made, but also the justification for making that decision. So there's no one size that fits all. The GDPR is based on the principle that institutions and organisations have to take ownership over when they share and when they don't share. But when you're drawing up that policy, you'll need to think of it in terms, in practical terms, of what will be relevant to your institution. So when are you going to share information with local safeguarding bodies? When are you going to be sharing information with multi-agent safeguarding hubs? When are you possibly going to be passing on to information regarding vulnerable young people who are moving on? Another issue that I've come across is, when do you share information with an exam board when the young person doesn't want to give consent, that they're going for a very difficult period, but the school believes that that should be taken into account? That's something you'll need to reflect on in your policy. Coming back to those 7 principles: necessary and proportionate to the risks. I've mentioned that already. It's got to be relevant, adequate, so you can't be so circumspect or so vague that a decision maker can't actually make a decision on this information. You've got to be accurate, and that really means distinguishing between fact and opinion. You've got to be timely, and this is obviously particularly important in safeguarding and safeguarding emergencies. It's got to be secure, so ideally your institution will already have a relationship with the LADO and an appropriate mechanism for sharing data electronically, and thinking about whether or not email is sufficiently secure, and that will depend on a variety of contexts. And then coming back to that fundamental point, that the decision to share or disclose must be recorded somewhere, and that decision must be justified. There is, as I say, there is relevant guidance out there, but just to identify the relevant paragraph from the Keeping Children Safe in Education guidance, which is being updated from 1st September this year. Paragraph 112 has a specific provision about the designated safeguarding folder and how that has to be passed on, and how it has to be passed on separately from the main pupil file, because your safeguarding information has to be kept secure, and only people who need to see it should be able to see it. So that means ideally you would have it as a separate file. With regards to retention, the best guidance I've been able to find is that from the Department for Education and the Information Records Management Society and the NSPCC recommend that the following: so that for the young person, they are kept for 7 years after they finish school leaving age, i.e. until they're 25. But if the concerns are about adult behaviour, they should be kept until they are 65, or 10 years after they've retired, or 10 years after the incident, if that takes them past retirement age, whichever is the longer.
Thank you very much, Joe, in making what we know is incredibly complicated seem slightly more straightforward. Now, my ostensible title is running an investigation, but I just wanted to stress again, I think that the main difficulty with the issues that have come out from Everyone's Invited are young people don't want to report these things to the school, and there needs to be a fundamental shift for that reporting to take place. When they are reported to the school really is hidebound in most serious cases to report it onto the police and social services, which young people don't want them to do. And therefore you get into this bind that everybody knows that something's happened. Thirdly, young women in particular, and the tyranny of niceness, as somebody described it to me today, young women in particular don't want to get the boy who has sexually assaulted them or raped them into trouble. Now, we might query that, but we're not 18, and I think we all recognise what peer relationships can be like at that time. So you've then got difficulties with them not telling you who it is, or if they do tell you who it is, that then being shackled round with all sorts of issues about confidentiality. There is then the massive problem that even though the teachers may only know half the story, the children know the entire story of what may or may not have gone on at that party, or what people may or may not have said. There might be videos floating around of what may or may not have happened. There's highly likely to be WhatsApp messages, text messages, Snapchat, various other forms of social media at which these issues are discussed. And if you are a school leader, I would suggest it is phenomenally difficult for you to run an investigation which is fair, which takes into account everybody's different conflicts, and basically you're engaging in a sort of quasi police investigation, even though you shouldn't be, or you don't necessarily need to be. So these are just some practical things which I have started to think about how, as a head teacher or as organisations advising head teachers or those who are running schools, governors, how you can try and make the best of what is a very complicated task. So I've got three things: when, how, and dealing with appeals and complaints. First, when. So the question is, when do you as a school run an internal investigation? Now, the disciplinary guidance suggests that you can run an investigation which is coterminous with police and/or social services action. However, my experience has been that the minute that social services become involved or the police become involved, they will say to you, do not carry out an internal investigation until we have finished our investigations ourselves. Now, if those investigations were going to be quite short, then one could see the merit in that. However, certainly in terms of the police, and it's clear that in all these cases, if there is a report of rape, assault by penetration, or sexual assault, and obviously sexual assault ranges from sort of over clothes groping through to everything which isn't assault by penetration, so there's a wide spectrum there, then the starting point under the statutory guidance and the legislation is that it should be passed on to the police in parallel with children's social services, and that a referral to children's social care should be made where a child has been harmed or is at risk of harm. And I can think that there would be very few circumstances where, even if the child wasn't the subject of sexual assault but had been the subject of sexual harassment or bullying on the grounds of their gender, that it would not be a risk of harm. So the guidance says, right, get on with it in effect, but I'm not sure how practical that is. Firstly, in respect of the police, I've never met a policeman yet who would recommend that you carry on with an internal investigation whilst they are investigating. The difficulty with that is that the police's investigation of rape and sexual offendings these days, certainly at the moment, although I know that rape policy in respect of sex crime is changing, usually involves a young person having to give their phone up and for all the information on their phone to be taken off and analysed. That in and of itself can take well over a year. So you could easily be looking at a year or 18 months before the police make any decision whether or not to charge, or the CPS make a decision whether or not to prosecute. Obviously, the police do the investigation. It's ultimately the Crown Prosecution Service that decide if a prosecution should be brought. Now, if you are dealing with 18 months in the life of a young person, it's extremely difficult for you advising a school or for school leaders to sit there and create a situation of stasis which goes on that long. I would also identify the fact that although the guidance sets out issues to do with safety plans, my experience of safety plans, again, is that they are, one, incredibly difficult to set out, and two, although they can try and minimise the risk of the complainant and the alleged perpetrator meeting each other, or victim and perpetrator, depending upon the language you prefer to use, it inevitably causes a significant degree of harm and upset to both those young people during the period of time at which a safety plan is in place, tends to please no one, and tends to leave with a situation where everybody feels unhappy, nobody feels that the situation has been handled correctly. The other thing I should say is that there are often difficulties getting referrals or ensuring that you are speaking with and understanding what is going on with the police. Now, all these rape and sexual assault are investigated by specialist officers, and but often when you phone up to make a referral to the police, they will just give you a crime number and that's it. What I think needs to happen is all of you who work with schools need to speak to your children's safeguarding partnerships, need to speak to the Chief of Police and get in place a memorandum of understanding so that you will be speaking with the people who will be investigating this, so that you have a good line of communication between the schools, whether that's via the LADO third party or not, because otherwise what can happen is you could be getting 3 different sources of information from 3 different forms of police officers. And certainly you want to try and get hold of the RASO, which is the rape and sexual offending officers. There will be some in every police area. They operate slightly differently, but in order to find out exactly what's going on, by whom, and how long it's going to be taking. Social care. Now, for those of you who, as most of you will be advising schools or governing bodies, nearly everyone there are differing local authorities. As we know, the referral to social care has to be the referral to social care where the young person resides. And even if they are boarding, that would be where they live when they're not boarding. And the difficulty with social care referrals is that there are wildly differing thresholds as to whether or not social care will investigate, won't investigate, and what it does. If they do investigate, they will assess and examine both the complainant and the perpetrator, because what I would suggest is certainly in the more serious of these cases, you want to be looking not just for justice for the victim, but also to be able to undertake some therapeutic work, if at all possible, with the young person who has undertaken the sexual violence or the sexual violation, to understand why they've done it and to try and educate them and provide them with counselling and therapy so they don't do it again. And those sorts of services are often only realistically available via children's social care. Bernardo's run specialist services, the NSPCC also run specialist services. So you're then stuck between a rock and a hard place because you've got all these investigations going on, and as a school, what do you do? Now, I've already talked a little bit about safety plans. The other area in which I think there is currently, although the latest QC guidance has provided some more information about who do you refer to, sex crime and dealing with sexual violence requires a specific sort of therapy. It's not really any good just referring you to the common or garden counsellor, if one puts it that way. There are sexual violence services out there. There are specialist services for young people. However, they are difficult to access, complicated to assess, and there are unfortunately very long waiting lists. Again, I think that this is an area where all the schools in the area should get together, should speak to the CCG, should speak to the specialist NGOs and charities that they have in their area around about Rape Crisis, Women's Aid, The Haven, their independent sexual violence advisors, and get a common source of referral and information so that there is clarity of who can you refer to, who can do this specialist work around sexual violence. If there isn't, now the reality is the vast majority of cases which are referred to the police do not result in either a charge and or prosecution. What do you then do? So firstly, do not assume you can or will get the information from the police. The complainant will need to give consent, and or you would need to get a court order. And I think it's, whilst I can see it wouldn't be impossible for that information to be given to you via a court order, that's quite a lengthy and complicated process. Social services may also not want to give you information for reasons of confidentiality. And again, that may well be largely dependent upon consent. And don't forget, you have to undertake an investigation which is fair to both victim and complainant. The one thing I think should be stressed, it was stressed in the Ofsted guidance, but I'm going to stress it again. Saying that there is no further action to be taken does not mean that there is nothing in it. The reality is that the police are completely swamped with investigating sexual offending and investigating rape offending, and there are 1,000,001 reasons why they are not taken to criminal trial, many of which has to do with not wanting to upset the victim further, or wanting to ensure that the safety of the victim, it would not be appropriate for them to be put through the criminal justice process. So if anybody, and I hope nobody does still, but governing bodies, I find, often still have quite old-fashioned ideas about what that means and say things like, well, NFA means there isn't anything we can do. No, all it means is that there wasn't, for whatever reason, a criminal prosecution. It does not mean that there is not a case to answer on a disciplinary basis. So, investigations. My view is that the current guidance is wholly inadequate when dealing with these complicated issues. So there are issues which you have to think about, which is the complainant, that is the person who suffered the sexual assault, fit to be interviewed? Can they be interviewed? If not, is there material which led to the referral which is sufficient? Because it may well be that the only information you're going to have is what you were told or what you overheard when Jemima and Ruby were talking at the back of history class about the fact that Ruby was raped by peers on Saturday during the party they all went to. And you may well not have a lot more information. Can the alleged perpetrator be interviewed? If so, what are the implications of this? That, you know, I mean, arguably he may well incriminate himself, and that could then lead the police to reignite a prosecution if there were to be a confession, so to speak, in the context of internal disciplinary proceedings. Ensuring that the investigator has some understanding of what we call trauma-informed approaches. Now, that's actually a lot less complicated than it seems. However, what it does mean is having some understanding and being able to interview people sympathetically, sensitively, but also with an understanding of the impact that trauma might have on their lives and might continue, and also how to ask a non-leading question. Is there surrounding information? How do you get hold of that? How do you get a hold of people's phones, especially if you might be ending up investigating this 6 months or a year after it happened? Snapchat, things like that, disappear after a certain number of hours. Children are very good at deleting things off their phone. You sometimes, if you have an IT expert, can recover some things, but they're usually quite good at making sure that it's disappeared. I would recommend, certainly in the more complicated of cases, potentially thinking about using external investigators who have got some experience and expertise in investigating sexual assaults, whether that's in the workplace, via their role as the police, via their role as social services, or via their role as lawyers. Investigations. The perpetrator must have the right to know the evidence against them, and in this situation, one would have to be very careful about anonymising witness evidence. And in particular, one needs to make sure that they have access to relevant text, WhatsApp and other social media, because as we know, children conduct their lives almost exclusively via these mediums rather than, I don't know, speaking to each other. Previous sexual history. What I would say is that certainly what I have found in my experience is that in a number of these cases, parents don't mind if their children get excluded for hitting other children. Parents mind enormously if their children get excluded or there's a threat of them being excluded or disciplinary action taken because of their sexually violent behaviour, because it's seen, I think probably quite rightly, as a stain on their character. So often people like me, or rather criminal QCs, get trolled in and talk about somebody's previous sexual history, the fact that they were having sex with each other 59 times. But I have to remind everyone, this is not a criminal trial. Someone's previous sexual history, the fact that they might have had sex with each other 50 million times before, is nearly always irrelevant. And you need to be extremely careful, both when you're investigating and on the time, that the nature of their previous sexual relationship doesn't influence you as to whether or not sex on that occasion was consensual. Dealing with complainants, again, the main issue of dealing with complainants is, one, they don't want to report in the first place. Two, when they do report, they very often, once they know the length of time of the investigation, want to withdraw that. It is exceptionally difficult, but I think it should still be possible to bring disciplinary action, even if the complainant withdraws their complaint to you as an institution, providing that you have the information or evidence. Hearings. So let's assume you make the decision to exclude. You then have a right to a governing body hearing in the context of cases which involve whether somebody was or wasn't raped, or was or wasn't subject of sexual assault, unless you've got CCTV evidence, which you might have if it's in school, other than the fact that people sexually assault each other in school nearly exclusively in toilets, where there isn't, and for very good reasons, there shouldn't be CCTV. but you may well see them coming out of the toilets or things like that. There's very rarely relevant surrounding material, and most of the time, certainly in rape cases, the issue is one of consent. So there is no dispute that sex happened. The issue is whether it's consensual or not. So there's then a difficult question of, should there be cross-examination of the complainant and alleged perpetrator? Is it unfair not to allow such? My view is, again, as it's not a criminal trial, it's a disciplinary issue, there doesn't necessarily need to be cross-examination of both parties. But again, this is when criminal QCs get involved and it can make things very complicated. Training for the governing body, that they understand sexual violence, have had up-to-date training and understand about rape myths. Again, do not assume that your governing body are au fait with what the Met Police or current thinking of those of us who are engaged in this area all the time. There is a lot of, well, they shouldn't have got drunk. Well, frankly, they asked for it. Well, who knows what happened, that I have unfortunately heard over the years. And again, you need to adopt a trauma-informed approach to any hearings you have. Decisions, again, just to make it absolutely clear, all decisions have to be made on the balance of probabilities. The reality with sexual offending and the things that heads find difficult is, if there are fights, nearly always there are 25 people who've witnessed that fight. In sexual offending, it is nearly always one person's word against the other. You cannot, as a decision maker, seek to abdicate that responsibility on the basis that there isn't corroborative evidence, there isn't sufficient evidence. Just going to have to do it. But I would say that we would be greatly assisted by much better, more detailed, comprehensive DFE guidance as to how to manage these particular situations than currently exists. I will now answer as many questions as possible. I think I can't seem to see the chat on my screen. I'll invite all the speakers to come up. My chat has gone off. Josh, who's behind the scenes administrator, yes, if we can have everyone up. There are absolutely no questions, so I am going to generate some questions by saying, do you think schools should be responsible for investigating this stuff? Or do you think it's something that social services should, in reality, take over responsibility from schools? Panel.
Open question. Okay. I think schools are generally quite ill-equipped to investigate. I think it usually goes to the governing body and 3 volunteers come along and then try and do their best, and an investigation with fairly little legal input. So I think it's something that is more suited to social services, is my initial thoughts. Just one point to add, actually, there's a case recently, a university's case, which I've managed to find a reference to, AB and University of XYZ, helpfully anonymised, 2020 EWHE 2978, which was about a disciplinary hearing for a student, and it was found that, well, natural justice had to apply, but there need to be a balancing between the victim and the perpetrator, and there would need to be questioning of the victim to some extent by someone on behalf of the perpetrator, but the questions could have been filtered by the chair. But there wasn't, the decision to not allow any questions was unlawful and breach of natural justice. That's what reflects in the university's context what we've heard in schools.
I mean, I think the position in schools might be slightly different because you're dealing with slightly younger individuals, but maybe not. I mean, I think it's very difficult. I mean, if somebody's accused of raping someone, the idea that that person who's the subject of accusation has no right to ask any questions of the person who's alleging the rape is one that those of us who are lawyers find quite difficult.
Yeah, I agree.
Yeah, to add to that, 2 things really. Yes, I agree, and of course, I mean, I sit as a recorder in the Crown Court, and periodically have to see best ABE interviews of young people. Now, obviously, when they're very young, it's a whole completely different matter. But children who are 13, 14, 15, actually, one view might be that they ought to be able to be asked questions just as a matter of fairness. That was one point. The second point, and linked to criminal investigations, is this issue about phones. There is quite a lot of development in the law and in guidance in the criminal context about phones and downloads, and there's a lot of argument in criminal proceedings about disclosure of the downloads to the defence and what's relevant and what isn't, etc. And that's all got its own issues, obviously. But added to that is a very basic practical one. When the police take a person's phone, they hold on to it, often for ages. And yeah, well, it depends. I mean, I've seen cases where the phone in question was needed. It was the business phone, and so it was needed. And so the police were able to download, they managed to book it into somewhere in London, and it got downloaded in a short space of time, and it was returned all within about the space of a week. So that I have seen. But in much more kind of run-of-the-mill things, phones don't get returned, often for absolutely ages, months, even though actually it's been downloaded. It sits in an evidence bag. And it sits there because, of course, when there are questions potentially about, well, who handled the phone and what happened to it, the people who interrogate the phones need to be able to go back to the original phone, and it still needs to be in the state that it was when it was seized. And so I think simply on a practical level, the idea of police investigation, would fill young people with total horror at the idea of losing their phones.
Yeah, well, I mean, that's it. That's what often happens is the young person will make the disclosure to somebody at the school. The school will refer it to the police quite properly. That's their job to do so. The young person's then told, firstly, you'll have to have an ABE, an Achieving Best Evidence interview, which we know isn't that scary, but if somebody says to you, talks to you about it, and that's one of the things where I think it would be really useful if the RASO officers came in and showed almost some fake examples of ABE interviews to show that actually it isn't that bad, it is okay, it's all doable. And secondly, they then get told, and your phone's going to have to go. And to a young person, your phone's going to have to go is just like saying their brain is going to be removed for a period of time. I mean, it's just it's incomprehensible to them that they don't have it. And so they often go, well, we're not going to carry on anymore.
Yeah.
And, that I think is a really big issue that we as a society need to grapple with, which is the criminal justice process the right process for these sorts of things in young people? I think the answer to that is possibly in some cases yes, in some no. If the criminal justice process isn't the right process, is there some kind of restorative justice process that we should be looking at, or some kind of compulsory rehabilitation for the people who are the perpetrators, so that the victims at least feel that something has happened? I think there are some really complicated questions which arise, of which there aren't any really obvious and straightforward answers.
But on the restorative justice point, are you aware of other countries? Is there some comparable system or where they do that? Because I'm not aware. But again, you sometimes come across situations. I've come across a situation where, as you said, Fiona, everybody knows, all the children know exactly what happened at that party, and so the children ostracize the alleged perpetrator, and cold shoulder him, and it goes on for months, sometimes years, and then at some point the school gets wind of it, and the school does its best but doesn't do a very good job, and says, and then says to the child, in a case that I was considering, what do you want us to do about it? And the child then feels that the school is asking them, well, do you want us to expel them? And the child feels unable to say yes to that.
Yeah.
Obviously.
Well, that's why. I mean, there are all sorts of difficulties, and we've got a question from Michael Brotherton from Stone King about head teachers' decision making. But I think just on this point, it's very difficult to do restorative justice in sexual offending because it often involves one-on-one, and that's not necessarily appropriate. So when I mean restorative justice, I don't mean somebody coming into a room and saying, I'm sorry, although sometimes writing a letter of apology or some form of admission is helpful, but basically scaling up the kind of work on preventing further sexual offending by that young person. Because what worries me is that some of the sexual offending you see at school is part of the start of a pattern of predatory sexual offending. And what you need to do is work out who are those young people, or what is the nature of the sexual offending that looks like it will continue and therefore needs to be stopped. and what is a sort of stupid, drunken, one-off error, which is unlikely to be repeated. And that again...
Yeah, and what is the ignorance? Because the level of ignorance in children as to what is, in fact, appropriate sexual behaviour has nothing to do about becoming...
I mean, I have to say, having listened to a lot of young people recently, I have been shocked by their level of ignorance. It's really, really huge. Don't assume they really know anything. So Michael says, you say a head teacher shouldn't abdicate responsibility where there's no corroborative evidence, but a head teacher is bound by the balance of probabilities. So it can be almost impossible to make a decision other than by taking an educated guess as to who is being truthful, which seems unfair, and probably why the heads decide to try and manage both pupils staying in school. Well, Michael, yes, that's true, but that's the reality of most sexual offending. If you go to a criminal trial, a criminal rape trial, it's nearly always her saying, I was at this party, I got drunk, but I got so drunk I couldn't remember what was happening. I woke up and he was inside me. I mean, this is a sort of absolutely typical thing that happens. And he will say, no, she was really up for it. She was doing it, blah, blah, blah. And no, she wasn't passed out, blah, blah, blah. I think ultimately we have to recognise that sex crime, unlike any other crimes, basically is he said, she said. And the search for corroborative evidence is largely meaningless. Sam, particularly with your recorder experience, is that something that you've come across as well? I mean, something that...
Well, I mean, I don't sit in sex crime cases, so when I come across ABEs and phone downloads, it's usually in a slightly different cases. I do indecent exposure and those sorts of lovely ones, the ones that comes to Crown Court. So yes, but I mean, anecdotally, that certainly seems to be right. Although with kids, there do seem to be a lot of people that apparently were there and saw bits of things, because these are kind of children, especially teenagers, are herd animals, and it's whilst the very specific complaint might have been one-on-one, actually there's sometimes
certainly
so it's known as a pest.
Yeah. So, I mean, certainly I think, but the difficulty often with that is because, as you've identified, a lot of the time, all the young people have taken sides as to who's been believed. I think there is a degree sometimes of ex post facto, I saw them going, or I saw them, which if you reconstructed it, but certainly I think I would agree with you. If things happen at parties, people tend to have seen somebody disappearing off with someone up to the lie on top of the coats. I think that there seems to be quite a lot of lying on top of coats. That's still. But
there's also lots of videoing that happens. Things happen in groups, and then certainly lots of people will know how paralytically drunk a person was or drugged.
Yeah. So I mean, you do need to kind of speak to the wider thing, but sometimes it will be they were both drunk. Well, nearly always they were both drunk and they'd both taken drugs and they disappeared off. What happened there? Not really sure.
You have to decide.
I think ultimately you have to decide, and you can't. I don't think you can say there isn't sufficient evidence. What you mean to say, I'm not happy with the evidence, but that's a bit different. I think.
I'm aware of the time, Fiona.
Yes, I'm so sorry. We've run horribly over, and I apologise for anybody who hasn't been able to have their gin and tonic now that it's 6 o'clock. So thank you all so much for listening to us. We will obviously have a recording of this out soon, and I thank you all very much for your for the interesting questions, and thank you to my panel for the really excellent talks they've given. Thank you. Bye-bye.
Bye.
Thanks everyone.